going live so you can learn what to do the first 24 hours after a DUI arrest. So thanks for joining, whoever's here or whoever's not here, whoever's here. So I really am doing this. It's a public service work. I'm not selling anything. I'm giving free information to help you in this difficult time. So if you've been arrested for your DUI, or if someone you love has been arrested for a DUI, then these 7 things will help you get through this tough time. I know it's stressful and overwhelming to get arrested for a DUI. So if you've been arrested for a DUI in Tennessee, then these things to do within the first 24 hours can greatly ease your worry, ease your mind, and get you on the right track. Okay? So a little bit about me. I'm DUI Nash, attorney Brian Lee Nash. I've been an attorney for 15 years, and I help people in Nashville and Middle Tennessee with their DUIs. So I found that clients that take inspired action after they've been arrested, which is very overwhelming, very stressful, it leads to success. And it may not be the exact outcome you want, but throughout the whole process, you're going to be set up and you're going to feel better. So the things to do, the first thing to do, if you've been arrested for a DUI, is bond out. So jail sucks. You don't want to be in jail. So bond out of jail. Find a local company. There's in Nashville, where my office is, there's many bond companies around there. And if you need advice or a recommendation, I can definitely give you one. Jail sucks. So bond out of jail. If you or your loved one are in jail, then the first step is to get out of jail. It's no fun, and it's really difficult to fight your case when you're in custody. You might not make the best decisions. You might just take a plea deal that is against your best interest because you just went out of jail. So as much as possible, step 1, if you've been arrested for DUI in Tennessee, is to get out of jail, okay? So step 2, when you bond out of jail, the magistrate or the judge or the night court judge will have bond conditions for you to comply with while your case is pending. And so the idea of bond is they let you out of jail pending your DUI case, and the bond company promises to pay money that you'll show up for court. Okay, so if you pay a cash bond, when your case finishes, you get all that back. If the bond company pays, if you pay them a percentage, then you don't get the money back. But the goal of a bond is to ensure that you're going to show up for court. So maybe you've seen Dog the Bounty Hunter, and if you don't show up for court, they go chasing after you. So you need to read the bond conditions very carefully. There's conditions on there of things you can do, can't do. And in particular, there's on DUIs, especially DUI seconds and beyond, there's a requirement that you have an interlock device installed on your vehicle. And it's really important to do this to comply with bond conditions, but also with the bond conditions and ignition interlock device, if you get it within 10 days, if it's a requirement, then the time to have the interlock, the total time, stays on your, that time counts, okay? So it's important to read the bond conditions and to get it installed as fast as possible if that's a bond requirement, so you can get credit for all the time that you have it on while your case is pending, okay? So step 3 is to find an attorney who focuses on DUI cases, not just somebody that does them and then just going to go and plead you out. It's important to find somebody like us that focuses on DUI almost exclusively, and someone that knows the process, the steps, and has a clear plan to help you win your DUI. So step 3 is find an attorney who focuses or does DUIs exclusively, because they know the process, they can give you the plan, they know the things that will greatly increase the chances of getting your DUI reduced to something else. And some options are a DUI reduction to reckless endangerment, a DUI reduced to aggravated reckless driving, a DUI reduced to reckless driving, or a dismissal, which happens more than people think. So once you do your research and you find the attorney, the next thing you need to do, step 4, is to hire the attorney. So I don't know what other attorneys do, but I know we make it super easy for you to sign up and pay, and we do offer payment plans. So you need to find the attorney, hire the attorney, okay? So I don't know, again, what other attorneys do, but I know our process is we give you a to-do list. And excuse me, the to-do list is a clear plan on the steps of each step of your case and what to do and what not to do during your case. And we hold your hand every step of the way. And we found after helping hundreds and hundreds of clients that if you do certain things, if your case can get reduced or dismissed, this will greatly increase and tilt the scales of justice in your favor. Okay. So hire the attorney, start the to-do list. And then number 6, it's super important to stay out of trouble. You don't want to catch any new charges. You don't want to make it worse than it already is. And so this bad habit or this event led to you getting in trouble. And you don't want to continue getting in trouble while your case is pending, because that makes it difficult, very difficult, not only on the first case, but on the subsequent cases. And then number 7, you want to complete the to-do list as much as possible. We guide our clients through that. So if you have a different attorney or public defender, then you want to make sure that you do as much as possible on that to-do list. And some of the items on the to-do list are get an alcohol and drug assessment, for example. These carry a lot of weight, because instead of us just going and saying, hey, my client's not going to do this again, you can have a professional, ask you questions and go through that process. And then you go to court and we show that to the district attorney. So that's one example on the to-do list. Now, the other important thing, along with doing the to-do list, is to show up to court on time. It's super important you're on time. One judge in Nashville, he compares it to if you ever went on a trip and you flew in a plane, because you don't just show up at the airport the time that your plane takes off. So it's super important to get there early, make sure you get through security, and make sure you're in court on time. So those are the 7 things that you do 24 hours after a DUI arrest in Tennessee, and I'll recap those. Number 1, jail sucks, you want to bond out, okay? Number 2, you want to read your bond conditions carefully, and if a requirement is to have the interlock installed, you want to do that within 10 days. Number 3, find an attorney that focuses or specializes in DUIs, because that is your best chance of a reduction or a dismissal. Number 4, you want to hire the attorney, which for us is to sign up and pay. And number 5, you want to start the to-do list. So if the attorney doesn't have one, maybe they don't do DUIs all the time, but we have a to-do list and we send you this to-do list and you start doing those things and checking them off. Number 6, stay out of trouble. Don't catch any new charges. That just makes it worse. And number 7, complete as much as the to-do list as possible and show up to court on time. So those are the 7 things to do after you get a DUI in Tennessee. So hopefully that was helpful. And if you have any questions, comment, or reach out to us, we'd be happy to help. And now we're going to go into some Q&A, some questions and answers, most common questions that we get every day at our firm. So some of the questions that people ask are, how much does a DUI lawyer cost in Tennessee? And the best way to answer that is, if you have no money, then you should apply for the public defender. They are free or low cost. And so at one side of the spectrum, you can get the public defender for no money. There's other attorneys that are generalists, general criminal attorneys, and sometimes they do them for $500 to $1,500. Attorneys that focus on DUIs and do that predominantly like we do, it ranges anywhere from $2,500, and I've had clients pay me upwards of $25,000 for a DUI. So it really depends on your position and your ability to afford it, and also your resources. And there's a big difference between a general sessions case and a circuit court case. So just to help you understand that, if you don't know, a general sessions case is where most cases start, and that's where you go and you have certain options in that court. If you want to eventually have a jury trial, then you would have your case bound over to the grand jury if it didn't start in circuit court, or you would have a preliminary hearing and the case would go to circuit court. And cases start in general sessions court, and then if you want a full jury trial, eventually that happens in circuit court. So usually pricing for general sessions is lower, and then circuit court, where especially if you're going to go to trial, then the fees can get pretty high depending on the case, your history, the facts of the case, etc. So hopefully that gives you an idea of pricing. The other big differentiator is some of the cases that we know we're going to fight and go to trial, we may charge hourly. And so, but generally we have a flat fee practice. Most criminal defense attorneys in the area do. But some cases we do, charge hourly rate. So we have a retainer, and then we just track our time and bill hourly. So hopefully that helps you get an idea of what a DUI costs in Tennessee as far as the attorney's fees. Another question that follows up with that is, what are the total costs of a DUI? And I have a whole list, if you want that list of all the possible costs. The total cost of a DUI, I'd be happy to send that to you. Just comment or reach out to us. We'll send that to you. But there's a lot of costs involved in fighting the DUI. It starts with when you're arrested, the company tows your car. And so oftentimes the company, tow company comes, tows your car, they impound it. If it's evidence, they'll hold it until the case is resolved. If it's not, then when you bond out of jail, you go pick up the car and you have to pay those costs. Then the next thing that costs you might incur is if you're given a bond, then you're going to have bond money that you're going to have to pay, either the full cash bond, or if you get a bond company, a percentage of that. Then after that, if you have to have the interlock installed while your case is pending, you'll have the cost of the interlock device. If you're in Nashville, oftentimes they have you do drug testing or drug or alcohol testing while your case is pending. There's those costs. Of course, attorney's fees, we just touched on that a little bit to give you an idea of what attorney's fees cost. The things that you do on the to-do list, while you're preparing for your case, alcohol and drug assessment, there's DUI center. AA may not cost money, but there's a number of things that you do while your case is pending. If you wanted to do an independent blood analysis, there's cost to that. If you end up getting a DUI conviction, then you're going to have court costs, fine, and you're going to have increased insurance, because your insurance probably will go up because you have to have an SR22 certificate. So you have that cost, and not to mention, if you have a loss of employment or a reduction in income based on losing your job because of a DUI, if you're a professional license holder or a CDL driver, or you just can't have criminal charges at your job, then you may lose your job. So those are not exhaustive lists, but a lot of costs that are associated with the DUI. I remember seeing on one of the state of Tennessee driver's license forms on the back, a DUI costs $10,000. So I would definitely, with attorney fees and everything, you're looking at probably $10,000 total. So we talked about pricing of attorneys, overview of total costs for a DUI. I guess another big question that we get is, do we offer payment plans? And so I know a lot of law firms do. We do. We have a policy that we want to get paid up front, but we understand it can be kind of pricey. And so if you can't make the investment, then our policy is we offer payment plans if it's a certain distance from the courthouse, and it's not circuit court. So generally, if it's in general sessions court, we have a payment plan option, and we discuss that with you on the phone. So if you need a payment plan option, we offer it, and I know a lot of other attorneys do. Another common question that we get is how can they pay? Can you pay with cash? Can you pay with check? We accept cash, we accept checks, we accept Bitcoin, maybe some other cryptos, credit cards. We have a really simple process. We send your contract electronically if you are far away or you don't want to come into court, and you can pay via secure link that we send you via text and email. So pretty common things, but yes, we do offer various ways to pay. Of course, we meet a lot of our clients at our office, which is at 300 James Robertson Parkway, Suite 201 in Nashville. It's literally 0.1 miles or 0.01 miles from the court. It's a block away. We have free parking, 2 hours, up to 2 hours at our office. And so, yeah, if you want to pay in person, we accept cash, of course, also. There's other ways to pay also, Cash App, Zelle, Venmo. And so we try to make it as easy as possible on people that trust us with serving them and fighting their DUI. So let's continue with the frequently asked questions. A lot of questions we get, is there a consultation fee? And so it's very common, at least in Middle Tennessee, that attorneys don't charge consultation fees. Some do, some don't. We found that it lines up better with the way I approach business and life. And I love helping people and I love giving. So we don't charge consultation fees. The first call, there's no charge. And we answer all your questions and really help you understand the process and whatnot. And so that's why I started creating videos, because I wanted to just continue doing public service work and helping people. And we have a place to direct people that can answer all of your questions without even having to pick up the phone. You can just open YouTube or Facebook. A lot of people want to know if they can just do everything over the phone, via text or call, or they have to come to the office. And we offer all the above. If you want to come to the office, it depends on the situation, but sometimes, especially early in my career, 14 or 15 years ago, I would meet people at various places and help them that way. Another big question, which surprises me, but is people ask if they have to go to court. And so at some point, yes, in a criminal case, you have to come to court, at least in Nashville and Middle Tennessee, even if your case is dismissed. So it's super important that you realize that you're going to have to go to court. And even if the case is dismissed, there's oftentimes like first appearances, and if we waive your appearance because you're out of town. So I have a lot of clients that come in from other places, because Nashville is a big tourist spot, and they come in, they go on vacation, and they leave on probation. So it's very common, and we have tons of clients that are visiting Nashville and they get a DUI or public intox, something like that. And so we help them navigate that situation. And part of the investment in us helping them is we try to limit their travel expenses as much as possible and only have them come to court when it's necessary. And so, yes, at some point you will have to come to court. But if you have an attorney and they go above and beyond like we do, we really, really try to limit your travel expenses coming to court until it's absolutely necessary. So earlier, you might have just joined, but earlier I was talking about attorneys, the type of criminal defense attorneys. And for those that don't have the resources, the courts have public defenders or court-appointed attorneys that help you at no cost or a nominal fee, $50 or $200, depending on your income. And that covers the cost of the attorney, whether you're in general sessions court or whether you're in circuit criminal court. And so there's of course, public defenders or court-appointed attorneys. There's private attorneys like I am. And within private attorneys, there's attorneys that are general attorneys. There's attorneys that are flat fee attorneys. That means they just charge you one fee and that covers the court. And then there's hourly attorneys where they ask for a retainer. And then once the retainer is down to a certain amount, they bill you hourly for the different rates for the attorney or associate attorney or assistant or receptionist, etc. And so once the retainer gets to a certain point, then you have to replenish that. So there's different types of attorneys and how they charge. As far as location, my office again is in Nashville. But yeah, I've literally gone to almost every county in Middle Tennessee, if not all of them. I've been to other counties also, but generally, you want to get a local attorney, like we are. We're next to the courthouse. Local attorney we have good relationship with with all the core personnel. But that doesn't stop me from getting good deals wherever we go, because Tennessee law applies to all the courts. And if you have the ability, if the attorney has the ability to, build rapport quickly with the assistant district attorneys, the judge, probation, then you can get a good outcome like that. So, so yeah, we handle cases in Davidson County, of course, Williamson County, Montgomery County, Sumner County, Rutherford County. We've been to all of Hickman and all those. So yeah. Okay. So some more common questions are, how often will I get updates on my case? So we take pride in responding to everybody, when they call, and if not, we call them usually back within an hour, and definitely by the end of day. And so no, we don't call everybody every day. That would be overbearing, and the cost that we charge wouldn't make sense. And we have a schedule and a plan and steps of your case. So when you sign up and pay, we send a welcome email, and then we send a communication email, so you know exactly the best way to get a hold of us for customer service issues, or you can call and text or email us. Then we have every phase of a DUI mapped out. And so the next thing after you sign up and pay, we notify the court that we represent you, and we send a notice of appearance. And if we're going to waive your appearance, we send that. And then we apply for your blood alcohol content, your BAC. And so we send an email out to you that you can do it yourself. It requires 2 forms of ID, or we'll be happy to do it for you. And then we just work the case that way. And so as we get information, we of course contact you right away. As you get information, then you just send us on those channels. So not sure how other attorneys to do this part, but we definitely take pride in staying in direct communication with you and keeping you updated on your case as it progresses. And then the really big thing is we send a to-do list, and it's really important to knock off at least the most important items on that list. And that way you can increase the odds of winning your case. So, oh yeah, I addressed how fast we respond to calls and text. And yeah, we're available, and for you beautiful people, we're available. If you have any questions, I wouldn't put any confidential information in the YouTube or Facebook comments. You can direct message us, or just reach out to, you can go to 615nashlaw.com and submit a question there. We'll be happy to answer. There's no charge for submitting questions. Again, I'm only licensed in Tennessee. If you have cases somewhere else, we won't be able to help you, but we might know an attorney. I have a network of attorneys that might be able to help you. Okay, so next, what time should I arrive for court? It's really important to be on time. If you weren't on earlier, you just joined. I shared the story of a judge. He's awesome in Nashville. He literally tells people, he gets riled up when you're late for court. He could throw you in jail for being late. You could be in contempt of court. And side note is, I was thinking about it, and attorneys like me and military, the only 2 professions that I can think of that you would go to jail for not going to work. If you have another one, leave me a comment which one I missed, but those are the 2 I could think of. And so it's often that attorneys are in other courts, even within the same courthouse, they're in another courtroom and they're not at docket call. So it's really important to understand that your attorney might be late. They don't go to jail unless they just ignore the judge totally. Then the judge could find them in contempt. But it's super important to be on time. The judge gives the analogy that I was talking about. He's like, if you ever traveled, right, and you flew on a plane, you can't, if your plane leaves at 9, you can't show up at 9 o'clock. You understand that you have to get there early so you can go to check-in and check your bags, and then go through security to get to your plane in time to board early enough, right, before the plane takes off. And so it's a similar concept. You'll save yourself a lot of stress and the risk of going to jail for being late by just going early and being on time. And so every county's courthouse is in a different place, obviously. The clients ask where it's at. We always send calendar invites. We have the location, the time, location, and we also text our clients reminders to show up for court. It's super important to, plan that out ahead of time and make sure that you're there and on time. So, it's actually like, it's surprising, 100%. It's so surprising that one of the common questions that we get is, will I be at court with them? And I don't think they're asking, will an attorney be at court? Because sometimes we have other attorneys cover, court dates for us. But yes, that's the point of hiring an attorney, is that you would have an, attorney there with you. And so we're at every court date, with you. So yeah, that's one of the most common questions, but I'm always surprised when people ask that, because that's why you hire the attorney. So another common question is, can we get the court date moved? And yes, a lot of times you can get the court date moved. There's good reasons for that. One, if you're out of town and the officer's not there, or the victim or any witnesses that are supposed to be there, they're not subpoenaed, we want to make sure that they're subpoenaed. Meaning, subpoena means they're giving notice that they have to be at court, or they could go to jail. If they're subpoenaed, we want to make sure they're subpoenaed, so that way, especially if you're out of town, if you're coming from California to go to court, we'll double check that they were subpoenaed or that they're supposed to be there. And if not, we'll move the court date. If you're sick or in the hospital, or, some other, legitimate reason, then of course we can get the case continued by agreement with the district attorney's office. Other than some common reasons or some emergencies, you definitely need to be there. If you don't know if you should be there or not, it's always good to err on the side of caution and make sure that you are there. So continue with questions and answers. If you're just jumping on to the DUI Nash Live, we're here at public service work. We started out with what you should do 24 hours after a DUI arrest. We went over that. And just to recap that real quick, 24 hours after a DUI arrest, number one, you want to bond out of jail. If you're still in custody, jail sucks, get out of jail. If you are a loved one in jail, get them out. Now, if they need to go to rehab or something, then get them right into rehab. Number two, read your bond conditions carefully. It's very, very important that you follow the bond conditions, each and every one of them, so your bond doesn't get revoked and you land back in jail waiting for another court date. And it's super important in your bond conditions for a DUI, if you are ordered to get an ignition interlock device, a device where you blow on to start your car and keep it on, then you want to do that within 10 days, because in most cases, if you do that within 10 days, then the time that you installed it while in your case is pending counts towards the total time you have to have it on. Number three, you want to find an attorney. You want an attorney that focuses or specializes in DUI cases, not a general attorney, as much as possible. Number four, you want to hire the attorney. And for us, it's very simple. We make it really easy. You just sign a contract and pay. And yes, we offer payment plans. And number five, we send you a to-do list after you sign and pay. We notify the court that we represent you. But for you, you want to do the to-do list as much as possible before your court date. And number six, you want to stay out of trouble. One of the worst things you can do while you have a pending criminal charge is to get into more trouble. It makes the first case a lot more difficult to win. And of course, it makes the second case a lot more difficult to win, especially if it's the same issue of maybe alcohol or drug abuse or misuse. And then they're going to realize you have a problem. And it's dangerous. So stay out of trouble, number six. Number seven, you want to complete the to-do list as much as possible before court, and make sure you show up at court at time. So that was what we went over earlier, just a recap of that. If you have any questions or, want me to expand on that, leave a comment. I actually can't see the comments right now, but I'll read all those and I'll respond to them. And again, I wouldn't put private confidential information in there. If you have, questions that you want answers to, that's confidential, you're welcome to private message us if you're on Facebook, or you can just go to 615nashlaw.com. We're happy to answer those questions. We're doing this public service work. We just want people to be safe. And if you're in this situation, we want to help you get through it and come out as in the best possible situation as you can. So One of the most common questions that we get, we'll go back to these. When will you get your blood or alcohol results, or blood test or breathalyzer results? So there's it's a lot less common now than 15 years when I started, that there's breathalyzer tests. But sometimes it happens that, you know, the cops will give you a breathalyzer, and I believe those are pretty immediate. They'll see what your results are there. If you do the blood test, then they'll arrest you at the scene, and then they'll take you to either a hospital, or some jails have a nurse and they take the blood there. And so if you get a blood draw, that will be at the nurse, you know, the facility at the jail where the nurse takes it. Or if you go to the hospital, then the process is, for at least for our clients, once you sign and pay, we'll apply. You can apply. We'll send you the instructions on how to do it, or we'll apply for your blood results, and they come back at different times. You know, the TBI. We'll send them when they're ready. One of the most common questions: can I still drive with a DUI charge? Yes. When you get a DUI, you still have a valid license. There's no restrictions on it. And so you can drive. There's no geographic restrictions. You can drive with a DUI charge. And if you get convicted of a DUI, you can still drive, but there's these requirements. One of them is within the first 10 days, you have to get a restricted license order, and the judge signs that, which allows you to drive legally in Tennessee for 10 days. If you're out of state, it's a whole different process. But if you're in state driving, you can drive with that for 10 days. That allows you to drive, get your insurance, get your interlock, you know, go to the Tennessee Department of Safety, apply for your restricted license. And then once you get your restricted license and you get your interlock device, there's no geographic restrictions. And an interlock is required. So, excuse me, will I go to jail for my first DUI? Excuse me. Yes. The law says yes. If you're convicted of a DUI first and your blood alcohol is 0.08 to 0.149, then it says you need to go to jail for 48 hours. You must. And those have to be consecutive. Some counties, some courts in some counties allow you to go to the DUI center, which is a jail alternative, and you have to be there and you can't leave for 48 hours. So yes, the law says you need to. There are some exceptions. And of course, if your DUI is reduced, then the reductions, reckless endangerment, aggravated reckless driving, or reckless driving do not carry mandatory jail. So if you plead guilty to a DUI and your blood's 0.08 to 0.149, then it's 48 hours in jail. You get credit for any time you served. If you're going to go to the jail, the DUI center generally doesn't give it. Now, if you have a DUI, this is a DUI first, by the way. And a DUI first, if your blood's 0.15 or higher, then the statute says you have to go to jail for 7 days. And so that has to be consecutive. So a lot of times, if it's a good stop, if your blood's high over 0.15, then we're looking at getting it reduced from 7 days to 48 hours. That's assuming, right, that the stop was good, the investigation was good, there's no other factual legal issues, and so then we're really just trying to limit jail, especially if that's your main concern. DUI second has a mandatory 45 days in jail if your blood's 0.08 to 0.149. Generally, they give you the minimums on that because it's a significant amount of jail time. Some courts have alternatives to jail. For example, some courts have DUI court, some have mental health court, some have veterans court, and some have, you know, again, DUI court, where if you comply with the terms and conditions of this program, then at the end they'll reduce it to a lesser charge, for like a DUI second to DUI first. So if you got a DUI second, you're looking at 45 days in jail and 11 months, 29 days total maximum possible jail. DUI third is 120 days jail. DUI fourth is 115, and DUI fourth and beyond are felonies. So another common question: what do I need to do about alcohol classes in DUI school? So we give you a to-do list. We recommend doing these things before you actually go to court. And you got to be careful because you could spend money on DUI center, and some courts don't accept it, but in my opinion, it's better to do those and not need them and spend the money and hopefully it will help. But again, you just talk to your attorney and make sure that it makes sense for you to do all of the things. And so, yeah, but you definitely, if you have a DUI charge, you want to do an alcohol and drug assessment. You want to do, counseling or AA. You want to do things. It's really not so you win your case, even though that's a side effect. You want to do these things so you can learn new habits and behaviors so you can not get in trouble in the future again. And it just happens those things are what the district attorney's office generally want to see, to know that, hey, you're not going to go out and do this again and possibly kill somebody next time. And, if you kill somebody drinking and driving, you're looking at 8 to 40 years in prison. So it's just not worth it. Don't drink and drive. It's not worth it. And do as much as you can before court, because it does make a difference in your case. The district attorney, they're doing their job to protect the public, and they're looking at this report from the officer that says you were swerving, you got in an accident, you hurt somebody, whatever the facts say. And so that's what they're looking at. So you want you to do things so you can give to your attorney to go to court to show them, hey, that's not all there is to me. I'm actually a great person. And here's the things I've done to show that, hey, I'm a great person because I'm doing all these things. And you are, but you're doing these things to improve your life and grow, because there's really, no mistakes if you can learn from them. Okay. How long does a DUI take? So a DUI case, if you sign up, from the time you're arrested, it could take anywhere from 1 month if your case goes in there, you plead out, or in general sessions, they usually finish them within 11 months, 29 days. And so typically anywhere from 1 month to, a year. Now, if your case goes to circuit court, to the grand jury, then it could take a couple of years, 1.5 years to 3 years if you eventually go to a jury trial. So they sometimes move fast and they sometimes move slower, depending on the case, the facts, how complicated they are, et cetera. So let's see. So a few more questions before we wrap up. And if you just joined us, the main topic for today was what to do in the first 24 hours after DUI. It's so stressful and overwhelming when to get arrested for a DUI. You probably went out and you were celebrating, it was exciting, or you went out because of a breakup or you lost a loved one or something, and then you end up getting arrested. So I found the two reasons people, main categories people get arrested is because they're anxious, something with anxiety or excitement. They go out because they want to blow off some steam, or they go out celebrating a wedding, celebrating, a raise a promotion at work, birth of a baby, all kinds of things. And so if you get arrested for DUI, these 7 things are important to do within the 24 hours. So first thing you want to do is bond out. Jail sucks, so bond out. I'm a big freedom lover. So if you're in custody, you or your loved one, and you're wondering, should you bond out? Yes, get out of jail. It's so much easier to fight your case when you're out of jail. And a lot of times people take plea deals and take whatever the DA offers because they just want to get out of jail. And I get it. If you don't have any money and, that's what's happened in the past, then that's fine. But if you can, bond out of jail. Number 2, read your bond conditions carefully. It's really important that you follow those bond conditions so your bond doesn't get revoked. If you don't comply with them, then they can revoke your bond and take you back into custody. And specifically, you're arrested for a DUI, so read it and make sure that you don't have to get an interlock device, ignition interlock device. And it's important if you're required to get an ignition interlock device, that you get it put on within 10 days, because once you get it put on within 10 days, the time that you have it on while you're working on your case, if you end up getting a DUI or a requirement to have that, the time counts. So make sure you get the interlock device. Number 3, find an attorney that focuses on DUI cases, specializes in DUI cases like we do. That's why I go by DUI Nash. We help great people fight the DUI cases. And so you want to find somebody that focuses on that so they can not only win your case, but give you peace of mind and give you a plan and hold your hand every step of the way like we do. Number 4, hire the attorney. So you can find them. Well, you got to make the decision and hire them, and you got to pay sign their engagement letter, their contract, and then pay them. And yes, we offer payment plans. So if you can't afford the investment for us to fight for your freedom, we have certain criteria that we use and offer payment plans. Number 5, we send you a to-do list. I don't know if other attorneys do, but we send a to-do list, and you want to start the to-do list, and you want to do as many of the things on the to-do list as possible. Number 6, you want to stay out of trouble. Don't get new charges. Don't get violations of, any new violations, including speeding tickets or anything like that. You want to just stay out of trouble, work on yourself, grow, so that way you can improve your life and ideally increase the odds of winning your case. And number 7, back to the to-do list. Make sure you keep working on the to-do list. It helps you focus. It helps you not be so anxious and stressed out, because you're focusing on something that's going to change your life and greatly increase the odds of winning your case. And within this, doing the to-do list, part of the to-do list is show up to court on time, so that way you don't get arrested for contempt of court for being late. The judges don't like that. So those are the top 7 things to do if you've been arrested for DUI within the first 24 hours. Do those within the first 24 hours, and you're going to feel a lot better, and you're going to be on a path that will set you up for success on your case, regardless of the outcome. You're going to be set up for success. Okay, a couple more. What documents do you need to bring to court? It's always wise. It's funny because I have clients show up with nothing. They've gone to DUI center, they've done these things, and they show up with nothing. So we try to remind everybody, bring any and all documents that you think might help. I don't show everything my clients bring unless I think it's going to help. So if you went to the DUI center, or you've been going to counseling, or you went to AA meetings and you kept a journal, you have a coin, bring those things. Like, they make a difference, because again, the DA is looking at your paperwork and seeing the bad things, or the unhealthy things, the negatives. And so you want to come to court. We have our clients send it to us, but you still want to bring the originals, even if you sent to the attorney, just in case they need it. So yeah, you want to bring those items to court. So a couple more before we wrap up for the night. And just so you know, I'm going to be going live every day, at least every weekday. And so answering, it's all DUI content, DUI helpful information. So if you have questions or concerns, or want to know more about your pending DUI case in Tennessee, jump on the channel. The goal is to go live every evening. And so we'll be happy to answer your questions. If you can send them ahead of time, I'll be happy to jump on and answer them. When you sign up, we get a question, how do we get, if you sign up, you live in another state, or you live, our offices are in Nashville, and you sign up and you're in Murfreesboro, you just celebrated in Nashville, you automatically get a copy of your contract that you sign. You automatically get a receipt for your payment, when you sign up and pay the retainer, automatically comes to you. It might be in your junk folder. So yeah, that's about all the time we have for today. Again, I'm DUI Nash. My offices are next to the courthouse in Nashville. We're literally 1 block away. We have free parking, free consultations. I love helping people. I love to help you. Even if you don't sign up, if you have questions and you're stressed out, you're overwhelmed, then just reach out to us. You can go to 615nashlaw.com. It's also our phone number, 615-NASH-LAW, 615-627-4529. We truly want to help. We know it's a stressful time, and we've been doing this for 15 years, and we just really love helping people. I want to do this free, offer everything, give everything away for free. And I had a mentor that taught me, it goes, if you want to show somebody, if you want to show somebody that you can help them, is just help them. So I'm here, I'm helping, I'm giving. This is the day 1. I'm at least going to do this for 100 days. So this is day 1 of DUI Nash Live. My goal is to just give everything away to you, and serve you and show you that there's hope. If you charge with a DUI, you can come out of this better than you went into it. You can learn, you can grow, and your life can be wonderful after a DUI. During it, it doesn't feel like it, but it 100% can. We've helped hundreds of clients. I've had some say I saved their life. And it was a team effort. I didn't do it. It was a team effort. I give the guidance, and they did the things. And so if you have a DUI, make sure you find an attorney that focuses or specializes in DUIs like we do. I'm DUI Nash. This was the first live. Hope to see you soon, all you beautiful people.